The Judicial Commission of Inquiry into Criminality, Political Interference and Corruption in the Criminal Justice System enters its 18th day today with a new witness. SABC News reporter Canny Maphanga and presenter Ayanda Nyathi are in the nation's capital, keeping us abreast of developments and making sure that we are clear on what has gone over these past 18 days, Ayanda, and of course, what's to be expected today. Interesting conversation with Mbegezeli Benjamin about the evidence that was led last week regarding a judge who may be implicated and how he explained the threshold to be particularly high in terms of when a judge would recuse himself.
Absolutely, and it's on that very point, Sakina, we're hoping to pick up. Those allegations are startling, but we also need to be frank about how they're still untested. Despite that, though, we imagine that the judiciary has to do something. The question is, what does that look like? Canny Maphanga is our senior reporter who's been here at the Bridget Mabandla Justice College since this commission started. And Canny, we might as well start there. And Nhlanhla Mkhwanazi again had suggested when he gave his testimony that the judiciary in some ways was involved in these claims of interference, or at least was in the pockets of some politically connected individuals. And in the past week, we've heard from witness A, B, and C that that might be the case. Help us once again get to what the nub of the allegation is, and I suppose what some of the unanswered questions still are.
From both instances where we saw members of the judiciary being implicated in the evidence before the Madlanga Commission, it was off of the base of what the witness perceived from the conduct. So not necessarily that it has been proven that the conduct was untoward, but what the witness perceived to be incorrect. And that theme carries on to witness A and B's testimony, because they're stating that they had all of this material where they're stating that it was shown that Katiso Molefe had a drug conviction, related conviction in the UK, that he had used false identities. They're stating that they had a number of exhibits that form part of their docket, and they're stating that because it was a Schedule 6, the onus was on Katiso Molefe to prove that there were exceptional circumstances, and that when the judge made that order, allegedly, there were no exceptional circumstances that were provided to them as the IOs to understand as to how this candidate was suitable for bail. Now, it's a tricky terrain to look at, because they're stating that he looked at the papers and decided on the papers. Now, when a matter is on appeal from the High Court, you will file your papers that the judge has to be quite well versed in prior to hearing the matter. How witness B perceived it is that she understood it as the judge had already made up his mind. She then goes into the actual hearing itself and states that she felt that the judge was being lenient when the judge was stating that he didn't want to be too restrictive in the bail conditions, felt that the judge was leaning more to the defense's side and not the state. And then, of course, there's this allegation about Katiso Molefe allegedly paying his way out. And the only inference one could draw is that if he got bail, that for some reason the judge would have allegedly benefited from that. So it's a lot of allegations being made about the acting judge president, and it becomes more critical because this is someone that occupies a very senior role within the Gauteng High Court Division. And the difficulty with the judiciary, which is why it's so difficult for a person to remove a judge in terms of Section 177 of the Constitution, because you want to get away from that area where someone who may not like a judgment that a judge has given or something of that nature, it can't be easy for you to just get rid of a judge. You need to have substantive evidence that you can put forth before the JSC for them to investigate before you actually even reach a stage like that. So it's a very tricky area because there's an allegation here, but it's not tested. Witness A and B are holding on to their firm belief that this conduct was suspicious to them, and they felt that it was part of that theme of various institutions acting in alleged collusion with those criminal syndicates. But again, it's tricky because the evidence needs to be substantive to appreciate that kind of submission.
And I suppose this should drive the point home. On the one hand, you need to be careful that the institution is not pulled into the mudslinging, right? And now needs to constantly respond to allegations, as you've mentioned, which aren't tested. But on the other, it's hard to keep quiet.
Yes, the judiciary is different in that when you speak of one, you speak of the institution. People rarely isolate an individual from the institution. That's why you have to be careful about the kind of allegations you make, and you have to ensure that you actually have the evidence to back it up, because although we are talking about the acting judge president, it is the judiciary now that is suffering. And if you have a judiciary that is not respected, a judiciary that the public don't have confidence in, then what do we make of the rule of law in society? If society doesn't believe that in this institution, can it exist in our constitutional democracy, and can it continue to safeguard all of these advances we've made in this new dawn? So it's quite a tricky area, but also it's important not to shield that kind of evidence, for it to be done in a transparent manner. But even if that's the case, I don't know how far the Madlanga Commission can actually take this probe, because a judge is dealt with in a specific manner. It is regulated in terms of Section 177 of the Constitution, and it is particular processes that have to be followed, that also bring in the JSC Act if you want to bring about a misconduct allegation against a judge. And it's quite some organizations have said it's quite worrying that this allegation has been carried so far, and there isn't any complaints sitting before the JCC right now as we speak.
Absolutely. We'll see how this goes. But that was just one of the many issues that came from testimony last week, Sakina. Today, we're expecting a ballistic expert to take to the witness stand. In fact, all things considered, they should be here in person. And their testimony is important insofar as possibly connecting the dots insofar as firearms that were used in different crimes and what that suggests about this web of alleged criminality. So stick around. 9:30 is the time, and we'll certainly be live for you inside the Bridget Mabandla Justice College when it begins.
We're looking forward to that. Thanks so much, Ayanda and Canny, out in the nation's capital.